Support comes from the Missouri Forest Products Association, saluting Earth Day on April 22nd with an ongoing commitment to help offset carbon emissions with sustainable harvesting of Missouri forests. Details at choosewood.com.
Well, there's all these questions about, if the Tofurky people say plant-based meat or plant-based sausage, then they'll be okay. But if they don't disclose that, then they could potentially face some sort of a criminal problem.
I mean, I don't see this law being upheld if it would get challenged, because companies have rights too.
So the law and order crowd is not in favor of following the law on this one, huh?
I guess they like Bart's food too much. I don't know.
Well, it's interesting how people change their positions depending on what's going on.
Civil disobedience is proper when the people who are participating are willing to accept the reasonable consequences.
And in this case, the reasonable consequences could end up being getting COVID.
This month's Legal Roundtable touched on a host of big constitutional questions, from the First Amendment to sex discrimination, all through the lens of state and local litigation. I'm Sarah Fensky. This is St. Louis on the Air. A host of legal matters were in the news this month. You probably heard about the restaurant suing St. Louis County Executive Sam Page. Is there merit to their suit? Well, what about the Springfield woman who says she was fired for being ugly? Or what about the latest from the McCloskeys? Yes, the St. Louisans who brandished guns at protesters are back. Now they're suing one of the journalists who made them famous. So there's a lot going on involving the judicial system, and what better time to dig into the law with a panel of experts. And this month, that includes Bill Freivogel. He's a journalism professor at Southern Illinois University, Carbondale, as well as an attorney. Bill, welcome.
Hi.
And we're also joined by Eric Banks. He's a former state prosecutor and city councilor for the city of St. Louis. He's now in private practice at Banks Law. Eric, welcome back.
Good afternoon.
And last but not least, we're joined by Mark Smith. He's an associate vice chancellor and dean for career services at Washington University. Mark, welcome.
Thanks, Sarah.
So let's talk Tofurky. You know, I was dying to say that. In 2018, the Missouri legislature passed a law prohibiting, quote, misrepresenting a product as meat that is not derived from harvested production, livestock, or poultry. It seems pretty basic. So, Bill, how do we find ourselves in court?
Well, the one problem is that I believe it's a criminal statute. And, it sort of smacks of protectionism more than truth in labeling. So, there's all these questions about, if the Tofurky people say plant-based meat or plant-based sausage, then they'll be okay. But if they don't disclose that, then they could potentially face some sort of a criminal problem. Of course, there haven't been any criminal prosecutions, the state points out. I believe a federal court down in Arkansas last year threw out a similar law down there, but there's some differences between the two laws.
Eric, do you think Mark, let's go to you. Do you think there are any?
I was just going to say, this is part of a larger issue as more and more people become vegetarian or vegans. It's everything from and you've got a lot of laws being passed in different states trying to protect different industries. So whether it's milk, my kids buy soy milk. It doesn't come from a cow or any other animal. I've seen at the store cauliflower rice. It's not rice. It's made of cauliflower. And this is another aspect of it. And the argument is corporations have free speech rights under the First Amendment, and burger is a term that we understand as, a lamb burger is made of lamb, and a regular burger is probably made of beef or something close to that. And then a veggie burger is made of veggies. And so I don't see these I mean, I don't see this law being upheld if it would get challenged, because I think there's and you may have to say veggie burger, just like, you have to, sometimes you can't say things are organic because it has certain connotations. But I mean, companies have rights too.
So you think the judge, whether or not it's this judge in the lower court or eventually judges down the line, might well decide that this law is not constitutional?
Yeah, I think so.
Bill, you're a First Amendment guy. Do you think this kind of comes down to a First Amendment claim here?
Well, yeah, I noticed that I think the ACLU is they're the lawyers who are handling this, and yeah, I think so. I mean, particularly when you have a vague law, which is what the ACLU is claiming, and potentially criminalizes speech. Yeah. I do.
Well, this is going to be interesting to follow this one. And see what happens to the Tofurky Company here in Missouri. The ACLU was actually in court last week on a different matter as well. They were very busy last week, 2 trials at a time. And this is its lawsuit against the Missouri Public Defender's Office. Eric, what's going on with this one?
Well, this is the lawsuit that challenges the status quo, which allows some defendants to be incarcerated without the benefit of a lawyer for months on end. It's said that a parent can only be as happy as his or her saddest child, but by the same token, a society can only be as democratic as its weakest link. And the ACLU is challenging the intolerable conditions where people can languish in jail, primarily because they're poor, and not have legal representation.
And these waiting lists that the Missouri Public Defender's Office has used, they've said they're a necessary evil. Their caseloads are out of control. I think it's interesting. The ACLU previously sued over this same matter. They came to a consent agreement. The judge threw it out. She said that this agreement they came to was essentially unworkable since the judges weren't a party to it. That meant they could assign these cases to public defenders who would be forced to choose between violating the consent decree or being subject to contempt of court. Is there a way around this? We all agree that this situation with these waiting lists are terrible, but is there any thinking that these parties at the table, which is the Public Defender's Office and the ACLU, they can solve this without the judges at the table as well? Mark, any thoughts on that?
Well, there is a solution to this, which is the state of Missouri allocates more money to the Public Defender's Office. Unfortunately, they're not going to join the Missouri legislature into their lawsuit. And we should also note Mary Fox, who's been on the Legal Roundtable with us, has done a great job of reducing the number of people on the wait list. I think they went from something like 4,000 or 5,000 down to 2,000, but it's still a problem, as Eric said, and it's a critical problem. I'm not sure what the solution is, because until you get a judge somewhere saying to the state of Missouri has to allocate more money for public defenders, I just don't know what's going to happen with this, because it's like one of those squishy dolls where you press on one part and then it comes out the other part. They're just, I don't think there are enough public defenders here.
Yeah, it seems like this is a problem we've been talking about as long as I have been in this job, talking to y'all at the Legal Roundtable. There is a problem with our funding for Missouri public defenders. Mark, you noted that Mary has managed to reduce this list. She said there were 5,000 to 6,000 individuals on it when she took over, which was about a year ago. They've got that down to 2,500, and she says only 900 of those are currently in custody. How big a deal is it, though, that we still have 900 people waiting for a day in court, don't even have a lawyer yet? Bill?
Yeah, it's just like Eric said. I mean, you judge your society by how well we treat the weakest and the least powerful, and the fact that only 1,000 people are getting screwed now as opposed to 5,000, it's still a bad thing. And it's something, and we've said this before, this is a constitutional right. It's not like a nicety. The Constitution guarantees you the right to a lawyer, and we're not living up to our Constitution and the promise that is, that America offers, and I just think it's horrible.
It is just interesting to think of Mary Fox being the person forced to defend this suit, though. I mean, as you say, she's been a member of this roundtable. We all know her. She's a terrific person who wants to work really hard to get everybody a lawyer. Now she's the person having to defend this system that I'm sure she wishes wasn't in place. Bill, any thoughts on that?
Yeah, well, that's right. But I mean, she has, as Mark was saying, she has done some really, made some real improvements in more than cutting the waiting list in half, and a lot fewer people who are being held, in jail while awaiting trial. So those are really important improvements. But Missouri has, for many years, been at the very bottom of the national list of resources given to public defenders. Like 48, 49, somewhere around there. We have a company with Mississippi, and that's just a shame.
So it's interesting. Michael Barrett was the only witness for the ACLU. That's Mary Fox's predecessor. So I'm sure she would have loved to have been, but she's got to, represent the team and everything.
Yeah. Well, it's going to be interesting to see, as Eric's saying, it's hard to believe this system is constitutional, and yet is anybody going to find a way to change this short of the legislature doing the right thing? There's another case that's being heard today that I want to talk about. This is at the 8th Circuit Court of Appeals. This also involves the criminal justice system. This time it's the Missouri Parole Board that was sued. Now, the MacArthur Justice Center sued the Missouri Parole Board on behalf of 98 young men. They're a class action. They were sentenced to life without parole as teenagers. We actually did a whole show about this, not last Friday, but the Friday before that. The Supreme Court ruled it was unconstitutional to give kids sentences like that, and it made it clear it was retroactive. So these young men were able to get parole hearings after being behind bars for 25 years or more. The parole board didn't take into account the Supreme Court had said. Instead of looking at how they'd changed or showed added maturity, it was just looking at what they did back when they were teenagers. Now, the MacArthur Justice Center won, and as we discussed on our show, these men have started to be released. We had 3 of them talking to us about what their life is like now that they're getting out. So here we are back in court. The Attorney General is suing because he's saying he doesn't like these changes. What do you think could happen here at the 8th Circuit? Eric, any thoughts on that?
Well, I have long since stopped trying to predict what a court will do, which is probably why 98% of all lawsuits settle. But if I had to take a guess, my guess would be that the 8th Circuit is going to slam the Attorney General for its blatant disregard of prior orders.
What kind of argument here do you think the Attorney General has much of a case here to say he shouldn't have to follow these new rules agreed to on the lower circuit? Mark, any thoughts on that?
I'm not sure what his argument is. The other complicating factor in all of this, we've also had another lawsuit about the parole board kind of violating some constitutional protections that are afforded to parolees, like they're supposed to be told that they can get an attorney, and they got slapped on that a few years ago, and they were told you're doing better, but you're still not there, and so it's just too easy for politicians to say I'm being tough on crime. And I understand they don't want to have those TV commercials we all see where the one person that got through, you're going to be held responsible for that. But you got to do the right thing. And like Eric said, this is required by the United States Supreme Court.
Today is our legal roundtable. Oh, Bill, go ahead.
I was just going to say, I agree with Eric that it's not a good idea to predict what courts do, but the 8th Circuit is one of the most conservative circuits in the country, a lot more, I think, conservative than the U.S. Supreme Court. And the state of Missouri has a decent argument that the lower court judge imposed, a higher level of procedures for these parole hearings than the U.S. Supreme Court had required. So, yeah, and that the state's argument is that lower federal courts really shouldn't be in the business of requiring these heightened kinds of procedural protections. Now, I'm all for the procedural protections, but I can see that as I could see the state's argument as being a winner in the 8th Circuit.
Okay. Well, we'll continue to keep an eye on that one, too. I'm sure that all of these cases we've talked about on the top of the hour, this is not the last month that we're going to talk about any of these three things. Today, of course, is our Legal Roundtable, and we're joined today. That was Bill Freivogel of Southern Illinois University, Carbondale. We're also joined by Mark Smith of Washington University and Eric Banks of Banks Law. If you have a question or comment about anything we're talking about today, you can feel free to join the conversation. Give us a call at 314-382-8255. That's 382-TALK. You can also send us a tweet at STL on air, or you can email us at talk@stlpublicradio.org. We need to take a quick break, but we'll be back shortly. And when we come back, we're going to talk about those lawsuits filed by St. Louis County residents against the public health orders there. This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU.
Support comes from the Missouri Forest Products Association, saluting Earth Day on April 22nd with an ongoing commitment to help offset carbon emissions with sustainable harvesting of Missouri forests. Details at choosewood.com.
Welcome back. We'll return to our Legal Roundtable in just a moment. First, here's a local news update. Starting today, candidates for mayor of St. Louis can file their official paperwork. Board of Aldermen President Lewis Reed announced his run over the weekend. Alderwoman Kara Spencer, Treasurer Tashara Jones, and businesswoman Dana Kelly have also announced their candidacies. Mayor Lyda Krewson said last week she will not seek a second term. The primary is in March. Enterprise Holdings Foundation announced plans to spend $120 million to advance social and racial equity and to fight hunger. And the director of St. Louis Lambert International Airport says travel will be up about 5 to 10% this week over previous weeks. However, she said travel is down by about half from last year. Join St. Louis Public Radio this afternoon for local and regional news, and throughout the day on our website, that's stlpublicradio.org. And now back to our conversation. Today is our Legal Roundtable, and my guests are Eric Banks. He's a former state prosecutor and city councilor for the city of St. Louis. He's now in private practice at Banks Law. We're also joined by Mark Smith. He's an associate vice chancellor and dean for career services at Washington University. And we're joined by Bill Freivogel. He's a journalism professor at Southern Illinois University, Carbondale. And at the top of the hour, we talked about a number of matters that are now in trial or waiting for judges' decisions, all involving the state of Missouri. I want to shift our focus a little closer to home. Let's talk about St. Louis County. There are a host of restaurants that filed a lawsuit challenging County Executive Sam Page's new restrictions, which ban indoor dining. They can't do that for 4 weeks. Now, on Friday, they lost their request for a temporary restraining order. Bill Freivogel, does that mean this one is over?
Well, it doesn't mean it's over, because this is, they were seeking an emergency a court order, but it does seem as though, they're not supposed to go back to court for a number of days. So by the time, they get back to the next step in this lawsuit, the whole thing may be over. So, as a matter of fact, I don't think they're very likely to win. I mean, they're making the sort of same claims that have been made all through the summer about the St. Louis County not having the authority to take this kind of action. That Page can't delegate this power as he has, and I think their argument is actually fairly weak. I think it's really only in cases that are involving say religious organizations that I think is very likely that there will be a court decision that knocks down COVID regulations that are justified under police or health and safety rules, and this doesn't involve any kind of a religious or really First Amendment kind of claim.
It does seem like people keep kind of advancing this same sort of case, and it never seems to go anywhere. And yet people keep trying. Eric, what do you think is going on here, that we keep seeing the same lawsuit over and over, and it seems to lose every time?
Well, at first you don't succeed, try again. I think it's important to realize that while the battle is over, the war is certainly not. What the judge ruled in his 4-sentence order was on the temporary restraining order. The preliminary injunction, the request for a permanent injunction and declaratory relief, that's still in play. But as Bill said, before the judge gets to those issues, the 4 weeks will be over with.
Yeah. I mean, this feels like another loss. But what makes this one very interesting to me, at least one of the restaurant groups that filed this suit, this is Bartolino's, they had publicly pledged to stay open in defiance of this order. If they make good on this and they continue, say they're open for business tonight, does the county have a move here? Could they come after them in some way? Mark, any thoughts on that?
Yeah, so Wesley Bell has said that he's not inclined to criminally prosecute these folks. I guess St. Louis County could get some kind of injunction to force them to close. They could probably do that. What I find interesting about these cases, when you read in the paper or when you see them on TV, everyone's talking about the unfairness of it. That St. Louis City's open or St. Charles County is open, we're not, we're at a disadvantage. And that they haven't, seen any cases yet. But my understanding of their lawsuit, and I haven't seen the lawsuit, but from reading in the paper, is that they're saying it's more of a procedural thing. You didn't give notice before you did this, and county's saying we don't have to go to the county council or anything. So yeah, I kind of agree with what Bill and Eric said, which is I just think this is not a winner lawsuit, and yeah, they can try and violate it, but I'm not sure that's a smart legal move, and I also am not sure it's a smart move as a business. Do you really want to be the business that has seen, this whole COVID thing has gotten so politicized? I would worry about that too.
So speaking of it getting politicized, I thought it was very interesting to see the Jefferson County Sheriff tweeted last week after these restrictions went into place, after Bartolino said they were going to open anyway. He tweeted that he was there dining inside of Bartolino's, and I can't remember exactly what his comment was, but was sort of painting this as he was striking for freedom. Bill, could he face legal repercussions for this?
I don't think that he could. I mean, he can say he's getting a great dinner at Bartolino's anytime he wants to. I don't think he would face legal repercussions.
It seems like such a bad look for a law enforcement officer to be on the side of I'm going with the lawbreakers. Am I being too old-fashioned here that I was shocked by this?
Yeah, you're too old-fashioned there. No. Also, I think, didn't I see that Tim Fitch was also doing the same thing from the county council?
Former police chief.
He's not the only politician or public official who's been doing this.
Yeah.
Two of the Saracenos, Bart was on the police board with me, and then his brother was on the St. Louis County one. I remember going to Bartolino's on Hampton every Thursday at lunch. I mean, half the St. Louis retired white shirts from the St. Louis Police Department were sitting there having lunch together. It was like the scene. It was the place to be. So
the law and order crowd is not in favor of following the law on this one, huh?
I guess they like Bart's food too much. I don't know.
Well, it's interesting how people change their positions depending on what's going on.
And Sarah, just so that you know, I have no problems with the sheriff disobeying the law the way that he did it. I believe that civil disobedience is proper as long as it's nonviolent. I think that if the powers that be wanted to, they could issue a citation to the sheriff for violating the order.
Mm-hmm.
That is a reasonable, judicious response. I don't think that it would have been reasonable for them to tear gas the sheriff or to sick police dogs on the sheriff or to use water hoses on the sheriff. Civil disobedience is proper when the people who are participating are willing to accept the reasonable consequences.
And in this case, the reasonable consequences could end up being getting COVID. I mean, take a look at the White House and the list of the people working in the White House who talked a lot about no masks, and then they got COVID.
Yeah. Well, Eric, I guess I hadn't seen this that way. Thank you for helping me see this in a new light. If you see a grave injustice, it's our duty maybe to do an act of civil disobedience. And we all, I guess, have our different definitions of what these acts of grave injustice are. But you're right. Tear gas would not be appropriate. And I think we all know Wesley Bell well enough to say I don't see him going there, and it's good to have a prosecuting attorney who would not bring in the fire hoses. Let's talk about another matter involving St. Louis County. This has to do with its police department. There are 2 black lieutenants who have filed a lawsuit here, and their claims are pretty interesting. I don't know if any of you have read these claims, but they're basically saying that they were transferred in retaliation because they began to organize this union. This is a chapter of the Ethical Society of Police, which largely represents black officers. And they're also saying that this is racial discrimination. Eric, do you think they have a good case here?
Well, the term good is such a subjective comment. But what I do say to my clients who I represent who are employers, when somebody makes an issue as a result of their protected class status, you treat them better. You don't treat them worse. Because keep in mind that Nixon fell not because of the break-in, but because of the cover-up. And many times, plaintiffs will lose a lawsuit based on the underlying claim of discrimination, but win on the secondary claim of retaliation.
So you think there might be some evidence here that shows this kind of retaliation? That might be a really strong case for them. Mark, thoughts on that?
Yeah, I mean, you had this, a captain was made the chief. So jumping over all the lieutenant colonels, I'm sure that didn't go over well with the lieutenant colonels. One of these, this lieutenant colonel, I think this is a different case than what the 2 lieutenants you were talking about. But they're all kind of arguing about getting transferred around. And my sense is that is a way that the police department can punish people without punishing them. You go on the night shift, or you're sent out to this district, which is really far from your home that you don't want. And I agree with Eric that, it's this retaliation that'll often come back, and it's pretty clear what other reason is there for doing this other than that you complain.
It's interesting. Sorry, go ahead, Bill.
I was just going to say, it does seem like the transfers of these 3 high-ranking black officers smacked of some reprisals, and it certainly didn't help when the new chief made that comment about not thinking there was any systematic racism that had existed in the department. So I think that they have got an issue with the way they're handling black officers.
It's interesting. It seems to go beyond black officers. It's worth noting, KSDK notes that this term geography lesson, which is applied to people who get transferred out to the hinterlands, this was, quote, frequently thrown around at the 2019 trial of Keith Wildhaber. He's the gay police sergeant. He ended up winning a $20 million jury verdict because, he alleged this same kind of, they were messing with him. As Eric says, this issue of retaliation. When he would complain, they gave him a worse assignment. Shouldn't they have learned their lesson after a $20 million jury verdict?
Well,
a hard
hope
head,
so.
a hard head makes for a soft behind.
So what about this idea that they were organizing this chapter of the Ethical Society of Police? Aren't there laws also that specifically protect union organizing? Or am I dreaming from my days back in California, where I'm pretty sure there was such a law in the book? Mark, could they be in trouble for that?
Yeah, and it's not even forming unions. It's collective bargaining, organizing. I mean, anything that's for the collective good is protected under federal law. So, yeah, if they're retaliated against, that would they can't do that. Having said that, the police department is a paramilitary style group where you're supposed to salute and say yes, sir. And I think sometimes the high-ranking people start thinking, I'm all that, and I get to do whatever I want, and nobody gets to do whatever they want. We all are bound by rules, and a great way to get in trouble is to forget that.
Mm-hmm. Bill, do you think a jury will be sympathetic to this if it gets to this point?
Well, I guess it would depend on what the jury looked like, and I wouldn't be at all surprised to see something like this get settled. Why not try to deal with the issues and come to a settlement? I think everybody would be benefited under those circumstances.
Well, they say settlement negotiations are supposed to be confidential, but a little birdie told me that the gay officer's lawsuit could have been settled for $800,000 as opposed to the $10 million settlement after the jury came back with the $20 million verdict.
Yeah, you'd think even if they didn't learn that they're not supposed to do geography lessons, they might learn don't mess with a jury verdict, Eric. We're going to have to take a quick break here, but one thing I want to do real quick before we get to that, and that is I want to acknowledge an upcoming retirement. And this comes from someone who can apparently lay claim to what's the longest tenure of any current sitting judge. Mark, can you tell us about who's saying goodbye to the bench here?
Yeah, this is Bob Dowd, who's the chief judge on the Missouri Court of Appeals for the Eastern District. And Bob came onto the bench, I think, in 1978. He ran for what was the old magistrate position in the city, was appointed a circuit court judge by Ashcroft a long time ago, and then elevated to the Court of Appeals by Missouri Governor Mel Carnahan. Bob's a great guy. I'm glad that he has mandatory retirement. I'm sure he's got plans with his wife Denise to do lots of fun stuff. Bob is a testament to the Missouri plan. When we do our elections, we vote for the judges, yes or no. You get someone like Bob who was appointed by a Republican and then appointed by a Democrat and then was approved by the voters continuously for the last 40 years. And I think, Bob's kind of the poster child for the power of the nonpartisan plan, that our judges are just doing the law. Mm-hmm. So, and sometimes that gets called into question. So anyway, I wish Bob the best. I know he's from a very prominent legal family in St. Louis. There'll still be lots of Dowds around, but he's a good guy.
Lots of Dowds as judges around as well. So,
not as many as before, but there are still a couple.
We're running out of Judge Dowds. We'll have to do something about that. Our legal roundtable today is Mark Smith and Eric Banks and Bill Freivogel. We're going to take a quick break. Coming up next, we'll delve into the case of a Springfield woman who says she was fired for being ugly. This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU.
Support comes from the Missouri Forest Products Association, saluting Earth Day on April 22nd with an ongoing commitment to help offset carbon emissions with sustainable harvesting of Missouri forests. Details at choosewood.com.
Welcome back. We're talking to our Legal Roundtable, and today that includes Mark Smith. He's an Associate Vice Chancellor and Dean for Career Services at Washington University. And we're also joined by Eric Banks. He's a former state prosecutor and city councilor for the city of St. Louis. He's now in private practice at Banks Law. And last but not least, we're joined by Bill Freivogel. He's a journalism professor at Southern Illinois University, Carbondale. And before we get to that Springfield case that I just keep talking about because I'm so intrigued by the legal issues it represents, I do want to go to the phone lines. We have a caller here. Ron is calling from Ferguson. Ron, hi, you're on St. Louis on the Air.
My question would be, is there a cap on damages for sexual and racial discrimination? If they're not the same, why are they different?
That's a good question. I don't know if any of our experts here have the answer off the top of their heads. Does anyone want to take Ron's question here? If not, we can try to get an answer next month. Mark, you look. Eric.
There are caps on damages. I mean, it would depend upon whether it's filed under federal law or filed under state human rights law. I don't believe the caps are different for sexual versus racial, but I'm not 100% certain.
Eric, do you have any insight on this one?
Yes, there are caps, and many times the attorneys get past the idea of the caps by articulating the damages as being compensatory as opposed to punitive. So most of the caps that we see are on exemplary or punitive damages.
And so how would that translate, say, for a couple of police lieutenants claiming racial discrimination? Like how might that play out in real life?
Well, no offense to the third estate, the media, but what the jury and the press giveth, the settlements and the Court of Appeals and the process of remittiture sometimes taketh away. If I got a $20 million jury verdict, that would be on the front page of the St. Louis Post-Dispatch, or it would be at the top of your hour for your program. But if the Court of Appeals takes it away from me, that probably wouldn't be news.
That makes sense. And I have heard of this happening. So, Ron, we want to thank you for that question. And let's go to talk about this case here in Springfield. Missouri Lawyers Weekly recently reported on this very interesting jury verdict. This woman sued after being fired from her job as a grocery store cashier. She said she was fired for being ugly. A jury agreed, and they said she deserved $100,000. Eric Banks, is there a right not to be discriminated against on the basis of your looks?
Let me give a Harvard Law Review answer to that. Yes, no, maybe, sometimes. As your audience members know, we're living in a state where Missouri recognizes the concept of employment at will. That means absent a contractual provision, anybody can get fired for anything at any time, but for the reason of being a member of a protected class. So my employer, if I had one, would have the right to fire me because I was ugly, because I was follically challenged, because I was tall, but that employer could not fire me for my protected class status. Now, if I could prove that I was really being fired not because I was ugly, but because hypothetically I was a female, and males who looked functionally the equivalent of me i.e., not centerfold material or not a product of central casting, then that is sex discrimination. So I am reasonably sure that she won based on the argument of sex discrimination as opposed to they fired me because I was ugly.
That's a great Harvard Law Review explanation there, Eric. I'm getting this now. Mark, do you think is this a novel interpretation of the law, or do you think this has kind of been there all along?
No, it's I think she came to her lawyer saying, I got fired because I'm ugly. And he said, well, let's think about this and see how we fit it into the law, and probably ask her questions like, well, did other women get fired because they were ugly? Did men? And then he made the argument, like Eric said, well, no men were fired or disciplined or treated unfairly because of their appearance. So you're only applying this to women. So that's the protected class, and you're discriminating against only the women, not the men, based on appearance. Then the employer tried to come back and say, well, we didn't fire her because of that. We fired her because she was a bad employee. There were customer complaints, other stuff. But unfortunately for the employer, they didn't have any records of that, nothing, no way of proving that. So I think the jury was left with, well, we don't believe that. And we think she was treated differently because she's a woman, not because just of her appearance. So you don't get to say ugly as a protected class. I know that's what you wanted, Sarah.
I did kind of want
Not that you would never fit into that protected class, but I know you were excited about that.
It would have been a good headline.
New law.
Yeah.
But comments about a woman's appearance, whether they are that the woman is ugly or beautiful, they can equally be considered to be sex discrimination. I mean, that's what happened here. This was sex discrimination.
So you see, this is a pretty clear-cut way of how this law was supposed to work.
I see this as a very clear-cut way. You can't be saying to women in a newsroom, you're really attractive. I'm not going to send you out to cover a protest demonstration or something like that. I mean, this is creating comments about a woman's appearance can create a sexually hostile environment that can make it difficult to work in, or a racially hostile educational environment to make it difficult for a female student to study in, and that's potentially sex discrimination.
It's interesting. This actually reminded me of this Lampley case. Do you guys remember this? It was about a year ago. The Missouri Supreme Court found that it's illegal for employers to discriminate against people who don't conform to gender stereotypes. And this ended up, they again used these sex discrimination laws because he was saying he was fired because his behavior didn't conform to the stereotype of masculinity held by his employers, held by managers, kind of under that same rubric. It seems like people who think we're in an at-will state, you can fire anyone for anything you want. It's like, these laws here are written in a way that Missouri might not feel like they want to protect LGBTQ people, but the law clearly has found a way to do that. Eric?
Sarah, they tell me that there's a couple of fine restaurant establishments. I've never been, of course, but I think their names are Hooters and Twin Peaks, and they're known for their outstanding food. But based on what people tell me, they have a certain type of employee that they hire. And I always wondered how they could get away with it. So I did a little research this summer, and I found out the reason why Hooters can have a certain type is because they categorize the employees not as hostesses, but as entertainers. And they say that a bona fide occupational qualification for being an entertainer at our restaurant is you have to have a certain look. That argument, along with the fact that every time Hooters gets sued for sex discrimination, they settle for nuisance value.
A long time ago, Southwest Airlines tried to use that. They called themselves the Love Airline at the beginning, I guess because they flew out of Love Field, and also, to try to make other suggestions. And they only wanted to hire beautiful stewardesses. I guess we did call them stewardesses at that point. This is about a 20-year-old case. And so they claimed that was a bona fide occupational requirement to be beautiful for the Love airline. And that didn't fly.
But it sounds like it's flown for Hooters. And we appreciate Eric Banks doing his homework on this because honestly, that is a great legal question. And I have wondered about that in the same way I've wondered if there's a right to be ugly. So Legal Roundtable answering all your questions. This has been a good one. And here's another. Oh, Mark, let me have you jump in.
I was just going to say, and Eric, isn't BFOQ, you can't use it for race though. You can use it for sex, but like if I wanted to have a restaurant with a theme, I couldn't say, and only these people of this racial background can be servers in my restaurant.
That is correct. And you can also use it for religion. So if I am the principal of a parochial school, I could require that only members of that denomination be employed as teachers of that school.
Okay.
I think this BFOQ is.
And sorry, BFOQ is what?
Bona fide occupational qualifications.
Yeah. Oh, thank you.
And I think it's in the future going to be more and more narrow. So, the idea that a Hooters restaurant couldn't hire a man, I think that's going to get tougher and tougher in the future for them.
I can see that. Well, look, we only have, 8 minutes left here, and I have to talk about Mark and Patricia McCloskey. There's a rule that every Legal Roundtable since this incident happened that we have to talk about them. And this month, there are actually some interesting legal issues to talk about here. These are the Central West End residents. They brandished guns at protesters who just were taking a shortcut through their neighborhood. Journalists captured them on film as they were doing this. They became national figures. They got to speak at the Republican National Convention. Well, now they've filed a lawsuit. This is against Bill Greenblatt, a photographer with the United Press Syndicate. Did he have the right to take their photograph? Well, they say no. Bill, what does the First Amendment or what does legal precedent tell us about whether or not he had the right to take their photo?
Well, bottom line is I think he did. But I mean, their argument is they make a couple of arguments. One is that as they have claimed all along, the sidewalk out in front of their Portland Place house was a private street, so it was their private property. They were trespassing, they were invading their privacy, and then they make something called a right of publicity argument, which means basically you get to make money on your own image, so they're making all of these complaints, these claims against UPI and Bill, the photographer. And it's sort of interesting that they, one of the things is they say that this photograph has held them up to infamy around the country. Yet this is the very photograph that they have put on their Christmas card, which had.
Well, and Bill, we're having some trouble there. I think you've frozen.
Maybe we're going to send them. This is where we last dealt with the McCloskeys. Maybe we're going to send them a cease and desist order. I'm frozen.
You're unfrozen now, so continue.
Can you see me?
Yes.
Okay.
Yes. So yes, as you were saying, the McCloskeys sent this. Yeah.
They put this photo on the Christmas card, and for this year, and then UPI was saying, well, maybe we will send a cease and desist order because the McCloskeys are violating our copyright. Well, now the McCloskeys are saying it's not only did you UPI and Bill Richardson, did you invade our privacy, and we also should get to own your image.
So do you think this is just a proactive strike? They're trying to protect their rights to send this Christmas card, Mark?
I think, and correct me if I'm wrong, didn't Greenblatt sue them first, or not sue them, but send a demand letter to them saying, you owe me money because you used my image, which I have a copyright on. And for your listeners, a copyright means you have intellectual property rights to a unique expression of an idea. So it can be a photo, it can be a book, not to the idea, but to the unique expression of it. So he said, you owe me money for using my image. And so then they, like oftentimes, you sue somebody, then they sue you back. So they sued him saying, well, you used our image What I find is the interesting issues. There are apparently some companies that are also making money off the McCloskey's image, which other stuff. Now, I think that's the more interesting. I think Greenblatt could have an action against them, and possibly the McCloskeys could have an issue against them because people are making money. I don't see how Greenblatt is making money. I mean, that's news and it's First Amendment protection. And so I don't see that going anywhere. But I could see these other places maybe getting some there. But like Bill said, their argument would be undercut. If you're saying you're using that image to publicly humiliate me, and then you put it on your Christmas card. I also don't know that Greenblatt's got an argument against them, because think about it. If my kid is in the paper because he won a Fulbright to go to Bulgaria, we're going to put Michael's picture on our Christmas card, showing him get that thing. And if the Post-Dispatch would sue me, I think that's within the fair use.
Yeah, I got to say, as much as I'm not sympathetic to McCloskey's here, Bill Greenblatt maybe picked a fight with the wrong people. I mean, these people are known for just suing everybody for the dumbest things. It seems like that might not be the person you want to advance a copyright claim against. Eric, do you think maybe he misstepped on this?
I agree. I think that both of them are wrong under these circumstances. I think the photographer was within his rights to take the picture. But I don't think that you can take a picture of me engaged in a newsworthy activity and then say I cannot use my own likeness for whatever purpose I desire, whether it's Christmas cards or the like. On the other hand, I think the couple has demonstrated their well-deserved reputation for being litigious, so I'm not surprised that they would engage in this type of countermeasure.
Well, and on that
I think
note,
I was just going to say, I think they both have losing cases. I think that McCloskey can use the picture as a fair use, and there's no copyright issue that UPI or Greenblatt's got, and I think that the McCloskey's suit is a really weak one. This right of publicity and your privacy.
And on that note, we have reached the end of our time with our Legal Roundtable. Bill Freivogel of Southern Illinois University, Carbondale, thank you so much for joining us today. And Eric Banks of Banks Law, thank you.
Thank you.
And Mark Smith of Washington University, thank you so much.
Thank you.
Tomorrow on St. Louis on the Air, we'll meet musician Beth Bombara. COVID-19 canceled her show at the pageant. She's found other ways to connect with fans. We'll talk about that, and we'll learn about the huge changes we could use to fix our healthcare system. This is from a consultant who does work around the globe. More reporting from the St. Louis on the Air team is available at stlpublicradio.org. Never miss a conversation by subscribing to our podcast. You can find St. Louis on the Air on Google Podcasts, Spotify, Stitcher, and Apple Podcasts on the App Store. St. Louis on the Air is a production of St. Louis Public Radio. That's 90.7 KWMU. Thank you for listening. I'm Sarah Fensky.
Support comes from the Missouri Forest Products Association, saluting Earth Day on April 22nd with an ongoing commitment to help offset carbon emissions with sustainable harvesting of Missouri forests. Details at choosewood.com.